Any mention?
May I please, Your Lordship? I beg to mention item number 21, Lordship. Conducting counsel is out of station, Lordship.
You're here.
After 2 weeks, Lordship.
You'll be the conducting counsel today. What's the matter about? Small matter or big matter?
Small matter, Your Lordship.
Then? What's the issue here?
Your Lordship, it's regarding a stepping up of pay.
Oh, let us see. Yes, after 1 week, yes.
Authorised, Your Lordship.
Yes.
Please, Your Lordship, I beg to mention item number 24.
Number?
24.
No objection, Lordship.
What happened?
Personal difficulty, Your Lordship,
Of whom?
of arguing counsel, Mr. Philemon Nongbre. 2 weeks, Your Lordship.
Okay, 2 weeks.
Right, Your Lordship.
May I please, Lordship, I beg to mention item number 23, Your Lordship. I humbly pray that this matter be taken after 2 weeks, Your Lordship.
And with the respondents, Your Lordship.
There's no urgency in this matter.
Due to some personal difficulties, Your Lordship.
No urgency.
Some urgencies there.
If there's some urgency, then 3 weeks, yes.
Much obliged, Lordship.
Pleasure, Lordship.
If no urgency, we'll adjourn it indefinitely.
Supplementary list, item number 1.
Yes, Lordship.
Lordship, here the petitioner, he's a wife of late Basant Kumar Gupta because
Who's the petitioner?
petitioner is Daisy S. Gupta,
Wife of whom?
late Basant Kumar Gupta.
Who's Basant Kumar Gupta?
Basant Gupta is also deceased, husband of these petitioners. Wife, the
When you say
property,
Basant Kumar, he's a famous personality.
I think.
Well, last time your Lordship has done that has been demolished his illegal construction.
No, not that. Maybe court knows this, many cases.
Sorry, it might be famous to you, but
I don't know. So, but anyway, here the property was initially acquired by way of gift by his wife, Basant Kumar Gupta, late Indu Gupta. Indu Gupta died in the year 2010. Then after that, the property was supposed to be mutated in the name of the Basant Kumar Gupta. But during his lifetime, he could not do. And the property, he died also. He died 2000. Marriage between the Basant Kumar Gupta and petitioner herein was solemnized under the Special Marriage Act. And there's one child also born out of the said marriage. Now, Contempt Board, because there were some cases pending before the court, some people, some tenants, some occupants, they said, I am the legal heirs. They filed case against me to execute some documents. Then Contempt Board has filed an application before the court saying that first you get yourself mutated, then you can claim. Thereafter, what happened, Lordship, I filed an application for mutations. Mutation application, in the name of the dead persons, the person who already died. Then who will pay this tax? So the mutation is required. For that person, they have not yet mutated the holding to be mutated in the name of the petitioner, who is the only claimant.
Expires when? The lease with Basant Kumar Gupta or Indu whoever?
Indu Gupta. This is the gift deed.
Well, it expires when? Is there a lease subsisting in any?
The lease is that now, since the lease already is expired, now only
But
they
then
say.
was she mutated in the place of who gave it? Who you said it was her in her name.
In her name.
Let's see. Where's that?
You know, Lordship may see the letters is at 31. 31 because there is a lease, lessee and the co-lessee. Two lessees are there. One is a Balakrishna and Chetri, and another was a Indu Gupta. This is the two persons still is there in the lease, and the lease agreement also is in X. These are two persons, lessee and co-lessee.
No, where's that? How do you draw your line to this Indu? Where's the thing? The Indu Gupta was mutated?
Yes, mutated.
Where's that?
Lordship, if they see the demand notice, page 31.
It says new Indu Gupta.
Yes, Balakrishna Chetri. I'm not concerned with Balakrishna Chetri because he's a co-lessee.
Who's Balakrishna Chetri?
Said that intimated to the petitioner due to claim and counterclaim. From the first wife, he got a daughter. And this is a second wife who is claiming. The son is from the second wife. So claim and counterclaim are
No,
there.
no, no. Regarding this demand for payment arrears, it was served on her. Was served on whom?
No, Balakrishna's chapter is still there.
Okay.
Is it?
Then how do you address this problem?
Oh,
Is there any suit pending?
No, the suit is pending, Lordship, because the Basan
Is there a
Kumar,
suit pending?
because Indu Gupta.
Have you said that in this writ petition?
No, Indu Gupta, what happened, Lordship? The Indu Gupta, during the lifetime Indu Gupta, portion of the property she gifted to some 2-3 peoples. But the gift deed cannot be executed before the sub-registrar because the person died. Now they file a suit against me. I am Daisy Gupta. They file a suit against me. They are saying that you are the only legal heirs of Indu Gupta surviving now, and you are the one to execute. Now, Contempt Board file a reply saying that you cannot execute, I cannot execute unless my name is mutated, unless there is a mutation is done.
Utterly confusing.
So, for that reasons, we file an application before the Contempt Board saying that the property may
How will
be.
you address this problem? How will you get mutation?
No, mutation.
If somebody
title suit
claims
is
a
still
counter
pending.
claim.
No, title
Where's the
suit.
title suit? Have you mentioned
Title
it
suit
Yes,
is
sir, we have mentioned
36H of 2013.
Lordship, we have mentioned the title suit, but title suit it has got nothing to do with this.
It involves the same property, Your Lordship.
No, that is okay, but title suit is something different. बताओ ना क्या फटाफट people are so silently sitting.
Where have you mentioned that?
Yes, I mentioned.
यहाँ पे mention नहीं किया.
Yes, mention. Lordship, I mentioned in para 8. Para 8 said, the mutation of holding number 4JB could not be done at the earliest in view of the court cases filed against the late Basan Kumar Gupta.
So who substituted Basan Kumar Gupta in a title
Is
suit?
a husband of.
No, who substituted him? He's dead now.
After the yes, I am
substituted his place there in the
substituting. I am
suit?
substituting.
You're contesting there?
Yes. In all the cases, I've been continuing having no objection about my substitutions. So he's saying that.
Yes, this is a fixed problem. Yes. Can you file affidavit? How do you clarify this?
Yes, I'll find the affidavit.
Heard Mr. M.F. Kurishil is earlier counsel so-and-so. Issue notice Mr. S.P. Mohanta Leonard, signing counsel for the respondent, accept notice, no further notice called for. You don't to make anybody else notice, no Chitri, performer, nothing to clarify the matter.
I agree against the
Or else you
Contempt.
come later on and say that, oh, this Bal Badhu Chitri is necessary
No,
also.
we are not
since
concerned.
he's a co.
We are
They
not
are party in the
concerned.
title suit.
Anyway,
No, not a
yes,
party. Not a party.
just after 4 weeks is for instruction to affidavit.
Much
Item
more.
number 2.
Yes.
This is the matter where MSCRC has no objection, my lord, of matter being reheard, my lord.
Yes. Where's Mr. Jindal?
He's on next year.
We'll take it after some time.
Okay,
Lordship,
After 5 minutes.
may please, Your Lordship. Lordship, I have been instructed that this matter was deferred to this date on account of the appeal that we had filed before the division bench.
Yes, what
But-
happened to the appeal?
On account of unavailability of the Chief Justice, it couldn't be taken up, Lordship. I'm praying if this matter may be listed anytime next week, Lordship.
Yes?
With great respect, my lord, the intervention application has been filed in my petition, my lord. And that intervention application is also not allowed. And even appeal is also, my lord, no leave has been sought in file for filing the appeal.
Yeah, we have not sought leave to file appeal before the division bench.
No, there is no leave
Has leave been sought
my
from
lord. There
the
is no
to file
leave, my
appeal?
lord.
Because
And
you're not parties before this court.
Lordship,
So it was
Lordship.
leave sought
Lordship, an application craving leave,
for appeal.
Lordship, we have filed that.
No, that we
But
have
no
not
orders have been
received, and we
passed.
have seen.
No, Lordship,
Now
unavailability.
only one thing, where's the senior?
Lordship, he's not available today, Lordship.
He's not
I'm praying
available
if this-
virtually also.
No, Lordship, he has some personal difficulties, Lordship, to appear before this court today.
See, the thing is that the list is between, the thing is they agree with some orders passed by the Regulatory Commission
Lordship,
and which is court has state operation of.
Lordship,
And now you're seeking intervention. How are you affected by
Lordship,
the dispute, between these two parties.
Lordship, the orders that were passed by the learned MSCRC, Lordship, those are the tariff orders that will affect us because we are beneficiaries of the order, Lordship.
But then if the Regulatory Commission itself has no quarrel with the matter being reheard,
Lordship,
And they will be
if I may
heard,
pray,
my lord. I
if
am
this matter may be
boundless
listed
little
anytime
bit.
next week, Lordship.
It is my writ petition, my lord.
only hardship is this young lady is alone. Her senior is not here. That's the only thing.
I understand, my lord. That too.
And they won't be the Chief Justice won't be available till
To the 20.
maybe the
He'll be here on Monday, Lordship.
no, it's not here. It'll be till 29th, I think.
Yes, my lord.
Lordship, if I may pray, this matter may be listed on Friday, on the 26th.
I was only saying, my lord, I was subject to whatever you.
Lordship
I
will,
was
will
saying,
also
my lord,
produce judgments on hearing us, Lordship, for fair trial.
Fair
I was
trial?
saying, my lord,
For
I
fair
really-
hearing,
I-
Lordship. In terms of
I
the
take
intervention
withdraw
application,
the
Lordship.
petition, If I take to withdraw the petition,
Suppose we
the
take
line
up
of
the
statement-
intervention application now, and we find no merit since the meat of the matter is to go for reconsideration. So then you can
Yes, Lord.
air whatever grievances you have before the commission.
Yes, my lord.
Lordship, I'm on very limited instructions, Lordship, today.
Yes?
I'm on very limited instructions, Lordship.
Okay, we'll have it on Monday.
Obliged,
Yes.
Lordship.
Monday.
Interim order, you continue, my lord.
Yes,
Interim
MS
order.
De Cruz, who was learned counsel in the Miss Case number 125 of 2024, seeking intervention, submits that due to the unavailability of her counsel, the matter be adjourned for today. This court notes that the grievance of the petitioner is directed against the order of the Regulatory Commission, represented today by Mr. S. Jindal. Because in the interest of justice, this matter is on Monday for consideration.
Highly obliged.
Interim order shall continue, yes.
Daily list. Item number 1.
May it please your Lordship. Lordship, conducting counsel Mr. Hassan is on his legs now. I'm humbly praying that this matter may be taken up next week.
Lordship,
Who's appearing here, Mr. Dingdo or
no, Lordship, Senior Counsel K. Paul is appearing in this matter, Lordship. He's leading this case, Lordship.
what remains this case?
It's in their civil revision petition, my Lord.
Yes? It's been executed the decree now, or still remaining like that?
I apologize, Lordship. I'm not the briefing counsel in this matter, Lordship.
Yes, let's next week. Yes.
Highly obliged, Lordship.
Item number 2.
This matter is fixed for admission hearing, my lord.
Where's Mr. Dakhar? He was waiting for instructions. The Chinese, what instructions do you have?
Regarding this matter, we're waiting for a hearing.
No, that's the instructions. Your junior at short time, first before that is MS Iwanyang on 1st July that she needs some instructions. Matter to after 1 week. Then on 9th, Mr. Dakhar, same prayer. What instructions?
That with regard to some clarification in the affidavit, we got the instruction that the affidavit has been filed by the Secretary and the
What confusion? Yes, Mr. Suna. Or Mr. Shongwan.
Shall I start, my lord?
Yes.
May I please your lordship. Lord, by way of this writ petition, the petitioner before your lordship is challenging the impugned order dated 19/1/2024, my lord, and passed by the respondent number 2, who is the Subdivisional School Education Officer, Nongstein. The Impugned order, my lord, is annexure 10, page 35, my lord, of the writ petition.
Or you've been, you were head teacher before?
No, that is in the connected matter, which is the second WPC, which is connected.
Okay.
This is writ, my lord.
Yes.
Now, this is the order, my lord, if I may read. The following office bearers and members of the managing committee of Nong Dom Senrang LP School is hereby approved for a period of 3 years with effect from 29/5/2022 to 28/5/2025, subject to discharge as laid down under the rules. Now, the list of members, my lord, if I may just point out. Number 1, President Sebastian Tenhyang. This is also the president of the managing committee and who's also the Sardar of the village, my lord, has been.
This Torpinius Sebastian,
my lord.
Okay, he
is respondent number 3, my lord, in this writ petition. And the second is a secretary, that is Tropinus Sangriang, my lord. He is as respondent number 4. And the brief fact of the case, my lord, is that the petitioner before your lordship is the head teacher of the Nomdon Senrang LP School and also the former secretary of the managing committee, constituted for a term of 3 years, my lord. Now, as per the approval, the managing committee of the petitioner's school was constituted in the year 2019 and was duly approved by the respondent number 4 on 4th August 2020. And after the approval order dated 4th August 2020, my lord, the tenure of the managing committee has expired on May 2022.
Okay.
But however, the same could not be renewed and reconstituted because the respondent number 3 at that point of time, he was still holding as the president as well as the sorter of the village. And there were numerous complaints regarding the respondent number 3, to which he was duly occupied in the administration and discharging of his duties as sorter of the village, my lord. Hence, it was not be able. The managing committee has not been able to be constituted at that point of time. Owing to the delay of this reconstitution, my lord, the respondent number 2, white letter dated 19 June 2023, has summoned the petitioner and the respondent number 3 and 4 in his office chamber.
That time, number 2, that is page 21.
Yes, my lord. No. Yes, page 21. Annexure 2, page 21 of the WPC.
Sebastian Tendriang, he's shown as a village Sardar only.
He is a sorter, my lord.
Okay.
At the same time, he is holding the president of the managing committee.
And you had teacher number 2.
Yes. That is the assistant teacher, my lord. And after...
He's the secretary of the village also.
No, my lord.
It's number 3?
Number 3, no.
Sangriang's home.
He is the assistant teacher of Nongdom Senrang LP School, my lord.
Is a village functionary also?
No, my lord.
No. Okay. So only number 1. He's the
only
Sardar.
Number 1, my lord.
He's Sardar of... Okay, right.
Yes.
Right, okay.
And after the respondent number 2 has summoned the petitioner and the respondent number 3 and 4 in his office chamber, we have duly attended the meeting. And in the meeting, we have resolved that we should constitute the managing committee at the earliest. Yeah. And thereafter, my lord, what happened, the respondent number 3 has issued one letter, that is 2nd October 2023, and has instructed the, my lord, annexure 4, page 24 of the WPC, my lord.
Yes. This one, he's writing as...
My lord?
As a chairman of branch committee.
Yes.
What?
Yes, as chairman of managing committee, my lord.
And who signed secretary? You signed?
Yes, I have signed.
Okay.
The previous one.
Okay.
Now the English translation, my lord, is at page 25.
Okay, fine. Seen it. Yes. Okay. For reconstituted managing committee 26/9/23.
Yes.
Then
after we have jointly issued this notice calling for the meeting for the reconstitution of the managing committee, we have issued this notice to the village inhabitants also, that managing committee will be held on the 9th of the reconstitution and election of members of the new managing committee will be held on 9 October 2019. On the 9 October 2019, my lord, when all the...
2023.
To 2023, apologize.
Yes, then?
When the village residents, they have attended the meeting. They were present in the meeting, but however, the meeting for the election of the president and the office bearers of the new managing committee could not be carried forward because the respondent number 3, who is the chairman cum president of the old managing committee, without any information or intimation, he chose not to be present in the meeting. Hence, the meeting has to be postponed abruptly, my lord.
Okay, then.
And since the postponement of this meeting, no other meeting was ever held for the election and reconstitution of the managing committee. However, surprisingly, on 21st October 2023, my lord, the respondent number 3 came to the petitioner's house and asked the petitioner to put a signature in the ready-made format of the proceeding of the so-called meeting of a staff, the parents' meeting, and the SMC meeting, my lord. On perusal of the same, my lord, the petitioner noticed that her name was proposed as a teacher representative without her knowledge and the consent, which she refused, my lord, to put a signature on the paper before her by the respondent number 3. And thereafter, realizing the manipulative actually in attempting to reconstitute the managing committee of a school, my lord, without the knowledge and of the village, the petitioner on 23rd January 2024 has approached the respondent number 2 with a request to furnish the following documents, such as letter requesting for approval, resolution of the MC, resolution meeting, the proceeding of a staff meeting, and impugn approval order, my lord. And the first leg of contention here, my lord, is that prior to the notice dated 2/10/2023, with some other people in connivance with them, they have already held a meeting.
So there's
no, my lord.
What is this signatures and all? Is for your lecture 7, next page 30.
This is the meeting called by them without the knowledge of the village and of the petitioner, my lord. Now what happened?
So were you supposed to be there in the meeting also?
Yes,
Has
my
your
lord.
name been shown in the meeting?
My name has been reflected in this particular list, but I was never called. I was never present in this meeting, but simply they have just written my name there, my lord. Hence, in the signature column, my signature was never there. Page 29. Sir. Now, what happened before this meeting? Come back, my lord, which we have jointly called that a meeting for reconstitution of the managing committee will be held on 9/10/2023. But prior to this, on 9/9/2023, the respondent 3, 4, along in connivance, they have already held a meeting.
Okay, fine. Now you come to section 9. What is this? Start with the said overhead teacher. A teacher, meeting is discussed, letter from secretary. Like what is
Yes, here also, my lord, this is a document which is.
Request. Now your grievance is what? Firstly, is that there was resolution to reconstitute the managing committee, number 1, and number 2, you relegated from head teacher to assistant teacher. Is
Yes, that is in connected matter, my lord.
Right.
First, if I may finish this, my lord.
Yes.
Yes. First, the first point is that a meeting.
There was no meeting.
There was no meeting.
Okay.
And prior to that, they have already held their own meeting. They have already selected the members and all.
This was approved by the
yes,
SACU.
approved, my lord.
Yes.
And that is also in contravention of the. After holding the meeting, my lord, they have forwarded the president, who is the respondent number 3, has forwarded the office bearers' names to the respondent number 2, which is in total violation of this rule number 8, my lord, of the Meghalaya Aided Higher Secondary School Education and Upper Primary School Management Rules, my lord, from the Education Code.
The adopted or not adopted rules? Once reading. Which rules are you reading?
That is rule number 8.
No, which page?
Page, my lord, 208.
From the same book?
Yes, from the same book.
200?
208.
What rule is this? But this is not, is adopted this rule.
I think, Your Lordship, that rule of 1997 have been acted, Your Lordship.
No, this is not.
Lordship, yes.
All right. I will just drop it, my lord. Now, assuming if they say that the meeting, assuming that the meeting has been.
Even okay, fine. Your case only on that. There's a bogus reconstitution, bogus meetings.
Yes,
you've been relegated from. So what relief you're praying for here?
Now, those 20 people, my lord, which they claim that there is a village Darbar, cannot be termed as the total representation of the total population of the village. If I may take your lordship to the rejoinder affidavit which we have filed,
What have we said affidavit? What is
In the rejoinder affidavit,
what are both Sangriangs? Terniang and Sarniang. Terniang.
Terniang, my lord.
Who's appearing for Terniang? Why do you have the fraud meeting then? Yes. And who's appearing for Sangriang? Him. Okay. Yes. Okay. Now you see it. Okay. Right. What are you referring to, Mr. Shravan?
The rejoinder affidavit, my lord,
Yes.
to the affidavit in the position of the respondent number 3, my lord.
Number 3.
Number 3.
Number 4 is here, rejoinder.
Our rejoinder affidavit, my lord.
Yes.
I just want to show, my lord, annexure 6. Without going through the contents, this is the complaint against the Sorda of the village before the district council, but we are not going through the contents, man. I just want to show the total number of representation of the people who have already signed this document, who have already signed this complaint before the district council. There are around 65 total number of people, my lord. That is page 9 and 10.
In the village, only 65 people?
Yes.
Which reading for rejoinder?
Rejoinder, my lord.
No, rejoinder is... One second.
Page 9, 10. So are just the signatures to disprove the claim that they have the majority, my lord.
I'm continuing. Can you under the index? Oh, okay. What are you going to give me our page? Break it one. And after it's also rejoinder to the affidavit of respondent number 3.
Yes, my lord. Rejoinder affidavit on behalf of the petitioner against the affidavit in the position of the respondent.
Filed by SS Nongrum. Who's SS Nongrum?
My colleague, my lord.
Okay. Where, what do you want to show from
Annexure
here?
9 and 10. These are the signatures of the inhabitants of the village against the complaint which we have filed before the district council, my lord. Altogether
Regarding
are
what?
65 people.
Regarding a complaint against the headman?
Yes, against headman.
Against Mr. Changriso?
Yes, my lord. But
with regard to the school?
No, not with regard to school. Other works, my lord. Without going to the contents, I just want to show the total number of representation that we have.
Okay. Yes.
And plus the number that Mr. Sangreso and clients has is only 20, around 80 plus inhabitants we have. Another aspect, my lord, is that they have elected a person, respondent number 4, who is just a mere assistant teacher in total violation, my lord, of the government order dated 30th May 1996, which says that a secretary of the managing committee of the school should always be a head teacher, my lord. That is another contention, my lord. Again,
you will remove secretary now. You will relegate to teacher's representative only.
My lord.
You were secretary before.
Yes, ma'am.
Then in the reconstitution, you're just a teacher's representative now.
Yes.
So
according
even
to
in the
them.
managing committee also, instead of being a secretary, and now even in the school, from head teacher to
Assistant
teacher.
Assistant teacher, my lord.
Yes. Anything else?
And if I may take your lordship to Annexure 11, page 36 of WPC.
Annexure
Page
11.
36. Annexure 11, my lord.
Yes.
If my lordship is there.
Yes.
This is the letter which has been written by the Deputy Commissioner to respondent number 2 regarding the delay in the formation of the managing committee and my lord. And thereafter, page 37, Annexure 13, my lord, is a reply from the respondent number 2 to the Deputy Commissioner of West Khasi Hills, whereby he has found that, if I may read the last 2 paragraphs, my lord.
Yes.
On a meeting held on 27/6/2023, both the parties agreed to hold a village durbar and to select fresh managing committee members from both the parties and to submit to the OO of the undersigned for necessary approval. In this connection, fresh proposals have been received by the undersigned on 11/10/2023 and found that the head teacher did not sign the resolution of the teachers in order to settle this misunderstanding. The undersigned is intending to conduct a spot inquiry shortly. And this spot inquiry, which the respondent number 2 has stated here, my lord, has never been conducted till date.
Yes, Mr. Shulai.
May it please your Lordship.
Or basis you have the Constitution?
Lordship, in my humble and respectful submission, your Lordship, I would say that I would submit, your Lordship, that the approval is not as per law, your Lordship. Lordship, this is admittedly, your Lordship, this is a non-government aided school, your Lordship.
Yes.
So after the enforcement of the right of education, children to free at compulsory education act 2009, everything has to the constitution of the managing committee has to be done within that provision, your Lordship. If Lordship kindly first stick to the act, your Lordship, then Lordship kindly come to section 2F, your Lordship, of that act of 2009. F, your Lordship, elementary education. Then Lordship kindly come to N, school.
Yes.
So this school will come under 2I, your Lordship, an aided school receiving aid or current aid to meet or from the appropriate government or the local authority. Then Lordship, by virtue of section 38, kindly come to section 38 of the Act, your Lordship. That is the power of the government to make rules. And Lordship, in pursuance to this empowerment of the state government, your Lordship, the rule has been framed, your Lordship, will kindly come to the notification dated 1 August 2011. Lordship has gotten.
Where's the part regarding Constitutional Managing Committee?
Lordship, I'm coming, your Lordship. Lordship, kindly come to Rule 13 of that rule of 2011.
Yes.
Composition and function of the school management committee for the purposes of section 21. A school management committee shall be
every 2 years now.
Lordship, yes, we have to follow this. Then Lordship, kindly come
when did rules come out?
Lordship, that rule has come in 2011, your Lordship.
You have mentioned it in your 2011.
2011, your Lordship, yes.
How is that possible? Yes.
Lordship. Then Lordship, kindly come to.
That means all managing committees
it has
for
to
the
be,
state are illegal
Lordship,
now.
They have to,
No,
this
means
rule
all
has to be
illegal.
followed,
All of them 3 years.
It has to be followed, your Lordship.
That means that all managing committees will go now.
Lordship, yes. Certainly, your Lordship, yes.
Yes.
This is the rule. And Lordship, kindly come to page 13, your Lordship. Or Rule 13, your Lordship. I have
30.
No, 1
30
your
has seen
Lordship,
composite
yes.
functions school management
Lordship,
committee.
yes. Lordship. Then Lordship, in 2012, there was an office order, Lordship will kindly come, the office order dated 22/11/2012. What are the guidelines so far the general meeting of the school managing committee is concerned, your Lordship? Kindly come to office order 22/11/2000. Lordship, kindly see in portion of section 21 of the right of children to free and compulsory education act and so rule. It should be 2011, your Lordship, not 10. The undersigned hereby prescribe procedure and guideline for holding of school general meeting for election and selection of member of school managing committee. This guideline shall come into force with immediate effect and until further order or school other than school specified under so and so shall consume managing committee as per the procedure and guidelines. What are the guidelines here, Lordship? General meeting of the school shall be convened by the principal, headmaster, headmistress of the school, where only parents, guardian, local MLA, local MDC, Karbura, so and so, your Lordship. Including 2 members from a sponsoring body will be allowed to attend the meeting. Then admission to the meeting. On the day of the meeting, the admission register or name of the student class-wise.
Okay, fine.
Lordship.
So
then, Lordship, kindly see guideline number 3.
Yes.
Guideline number 3. Parents and guardians, 3/4 or 75%. Principal secretary, 2 members. 1 member of the local authority of the area, 1 member. 1 member from Kambura, Nokma, Soda, so and so. Total A total 12 members, Your Lordship.
Yeah.
And then, Lordship, kindly come to the next page. The members so elected in the school management committee shall have an advisory role. However, they shall select from among themselves a president or vice president and a secretary who shall be responsible for the day-to-day affairs of the school and to monitor the utilization of the grant received from the government from time to time. So, Your Lordship, the money committee has to be followed as per this rule, Your Lordship.
Yes.
Then, Lordship, so far the claim of the writ petitioner, Your Lordship, kindly come to the writ petition 26, Your Lordship.
26.
Lordship, that is the next item, Your Lordship. Lordship,
one second, I was going to affidavit whether you have said this or not.
No, Your Lordship, it has not been said, Your Lordship. It has not been said, Your Lordship. But this is the legal requirement, Your Lordship.
Fine. We'll do one thing. If that is the stand taken now, that is the requirement, then it will have far-reaching effect.
Lordship, yes.
If any order comes in this matter.
Lordship, yes.
Right.
It has to.
So
it has
what
to.
you do is you bring it on record by your affidavit.
Lordship, Lordship, yes. Then we can do
so
that.
better.
Then for the moment, if Lordship, if Lordship kindly come to page 50 of that writ petition number 26. Lordship, yes.
We thought we could dispose it of here, but if this is a new dimension, so 50.
Lordship, yes. Lordship, kindly see the claim of the writ petition is based on this order. What does the order say, Lordship? Except for minority school, all head teacher of non-government aided school, the school which is involved in the precedent proceeding, Lordship, is not a all head teacher of non-government school shall function as secretary of the school managing committee. Lordship, this has been superseded, Your Lordship, in my humble and respectful submission by the office memorandum of 2012.
Okay, anyway, so
let them bring them by record.
This matter was fixed at admission hearing. However, in the course of hearing, Mr. N.D. Shrai Leonard AAG with so-and-so has produced before the court the rules framed under the Right of Children to Free and Compulsory Education Act 2010, which are the, what rules are those?
Lordship, it is called
known as the Meghalaya
Right to Compulsory Education Rule 2011.
And also Office Order dated 22nd
November 2012
in pursuance to the said
Lordship, there
file in pursuance and
was
furtherance.
An amendment, Your Lordship, in 2014.
In pursuance and furtherance of the said rule, it appears that this aspect has not been brought on record by the affidavit filed by Respondent 2. According to matters as admitted for hearing, in the meanwhile,
we'll bring on
Respondent 2 shall bring on record with
Lordship.
also with appropriate submissions.
Lordship.
Yes.
Yes, just my Lord, since it is a very important matter, let the Respondent number 1 file the affidavit.
They will file the affidavit.
If the law officer file, I suggest if the officer state commissioner and secretary.
We'll file through the
Yes. List after?
Let it be 2 weeks, Your Lordship.
3 weeks.
3 weeks, Lordship. Fine. Apply, Your Lordship.
Very interesting. Because if this that means all the schools across the state will be
even in
there'll be a lot of fun, a lot of fresh elections.
Even in
all
that,
thanks to Mr. Shungwan, yes.
Even in that Nurul Islam case also, Your Lordship has made that observation, Your Lordship. That also I'll bring, Your Lordship.
But
that I'll bring, Your Lordship.
What's been going on is anyway. Law of the jungle, yes. Yes, Mr. Sheikh.
My Lord, here, my Lord, I received the affidavit, my Lord, but it's in the old format.
What?
My Lord, it is in the old format, so I have sent it back, my Lord, I received in this format, my Lord.
Further 1 week's time allowed to respond to the file affidavit. Expect next day after it should be on board, yes.
Item number 5.
You can copy to him. Give copy and prepare a journal meanwhile.
I'll give him, my Lord.
So you won't delay things. Yes. Yes. Mr. Sinkon. Yes.
My Lord, here the petitioner number 1, my Lord, unfortunately he expired, my Lord. So I'll seek
There are
some.
the three prisoners here.
In
Lordship,
item,
yes, there are
item number
two.
5.
Next item 6 is
5 and
No,
6,
no,
my
no,
lord,
no.
similar matter.
In this application.
Hilford, he died.
Hilford, he died.
Died. What about this Baramdo?
They all, Roderick Harbithai and this Richard Lingdor is similarly situated.
They are still there, my
We'll
lord.
strike him out and continue.
My lord.
Yes, it is informed by Mr. N. Singh Kwan that the petition number 1 has
Expired, my lord.
expired on.
My lord, I just received the information 2-3 days back, my lord.
Has expired. Such he prays that the Niyam's prison be struck off and the matter proceed with the 2 remaining respondents. Stop.
Then the registry will have to make a correction, Your
Accordingly,
Lordship.
yes, petition number 1's name is struck off, registry to make necessary correction
Lordship.
in the cause title. What about your additional affidavit?
State.
1, 3 and 5?
We'll need some more time, Your Lordship.
Why?
Your Lordship.
Then take after that same one, like Mr. Andy Shulai is also and for 1, 3 and 5 and MS Dia Karanlang for pre-phone around for a 2 weeks time for affidavit.
Apply, Your Lordship.
7.
Please, Lordship.
Yes.
Lordship, I seek some more time, Lordship, for
How
filing
many times
rejoinder.
you asked?
This is the second time, Lordship.
Your Lordship, if Your Lordship may have this matter after 1 week, Your Lordship. In this matter, there's an interim order, Your Lordship. As such, there's an
Enjoying
urgency.
interim order. So you're delaying the matter while enjoying the interim order.
Lordship, there are some documents which we need to bring, Your Lordship, into record.
We'll give you 1 week's time, last opportunity.
2 weeks' time, Lordship.
Rejoinder is not by right.
2 weeks'
Or
time,
you're
Lordship.
posted for hearing. Meanwhile, you file rejoinder.
We will be
within 2
filing,
weeks.
Lordship.
Lordship, 1 week's time, Your Lordship.
1 week's time. See, she's very
2
adamant.
weeks, Lordship.
Though 2 weeks' time has been prayed by MSN Karsim Blanc, for 2 weeks' time prayed for rejoinder, the same is vehemently objected to by MGC Marbo, who submits that the petitioners enjoying the interim order. So, however, in interest of justice, as last opportunity, 2 weeks' time is granted.
Interim order may be continued, Lordship.
This is the matter. Thereafter, interim order will continue. Yes.
Oblige, Lordship.
Item number 8.
We already filed, huh?
This, I think, what about
State we file, Your Lordship.
Mr. Sheikh? How much time you all prayed? We'll close it, then you MPSC? 18/6, 24/5. Like assorted lawyers, no? Ardata one day, S. Chanda one day, then see? Yes.
If we may file our rejoinder, Your Lordship.
How often rejoinder do not file affidavit?
For the state respondent, Your Lordship.
Yes, Tom told, who, Mrs. Naitang today, is the 4th lawyer now in this case, from the same chamber. Mr. S. Naitang for 5 to 11, 13, 15, and Mr. Aring for 12, 16, 18, 21, brave for allowed further 2 weeks last of to file effective affidavit stop. Is submitted on behalf of the state. The affidavit is already on board. MS neckline, MS 800 please fall allowed 2 weeks time to file rejoinder to the affidavit of the state. Is
Apply,
this
Lord.
thereafter.
Item number 9.
Please, Your Lordship. Lordship, the respondents are here to file their affidavit, my lord.
May I please, Your Lordship? I humbly pray 2 weeks' time, Your Lordship.
On behalf of, my lord, on behalf of respondent 3 to 16, we'll file on the next.
You already filed.
Not yet, my lord.
What's the matter about?
My lord, here what has
No
happened.
matter.
No, this is not no moment. My lord, here what has happened, my lord,
an impugn order was passed, my lord, by the chief executive member, my lord. We are aggrieved by that order. Prior to that, my lord, he has passed another order, my lord, transferring the matter before to the additional district judge, my lord.
When will you file affidavit? Within 1 week?
2 weeks' time.
You won't file within 2 weeks also?
No, we just received the instruction, Your Lordship.
You have respondent 3 to 16. Respondents brief for now further 2 weeks' time to file affidavits. Interim orders will continue until for.
Hello, Your Lordship.
Item number 10.
Please, Your Lordship. On behalf of respondent 2 to 4, Your Lordship, I pray for further 2 weeks' time, Your Lordship, to file.
Last chance will be given, Lordship.
Why last time? How many times have you taken?
This is the third time.
The fourth time?
Third time.
This said, Mr. Salam, please funds allowed 2 weeks further time for affidavit. Expected on the next date, the affidavit should be on board.
Obliged.
Item 11.
My Lord, we have filed a service report in respect of respondent number 4. As a president of the managing committee, my Lord. 1 to 3 is the government. They are yet to file their affidavit.
I'm yet to file. I'm yet to receive my comments.
Have you been served?
Yes, my Lord. Since 21st of June, my Lord.
You've been submits that the account force has been served and a service affidavit has been filed.
Yes, my Lord.
Regard stop. Accordingly, service complete. Mr. H. Harami, that's line Leonard so and so. For respondents.
1, 2, 3.
Praise funds allowed.
2 weeks time.
2 weeks for a time for affidavit. There's 2 weeks for affidavit and for appearance of respondent number 4.
4, my Lord. Obliged.
Item number 12.
May I please, my Lord, the notice to the respondent 2 has been received, and notice to respondent 3 and 4, they have reached the BO on 11th July. They have not reached the persons yet.
So we'll await service.
Yes.
You please have to take await service report on respondent 3 and 4.
Obliged.
Item 13.
Because in this matter, I am seeking time until Monday. It has gone for signatures and it is pending approval of the corporation. By Monday, we will be in a.
Don't worry, they'll be seeking time only, yes.
Lordship, no respondent are supposed to file the affidavit, Lordship.
They filed it?
No, Lordship.
Yes, as paid for a 2 weeks time granted to the respondent for affidavit. Just thereafter is.
Yep.
14.
May I please, Your Lordship. Enter appearance for us.
Very good. Why? What are you doing with the matter?
My Lord, no instruction yet, my Lord. We, on the late evening, we received the copy of the petition through mail and the wakalatnama also, my Lord. Kindly grant 2 weeks time.
You want only 2 respondents?
Only 2 respondents.
Mr. S. Hassan has an appearance today on behalf of the
Defense Ministry also should make party because
on behalf of respondent 1 and 2. Such a service is complete. Mr. Hassan, please for how much time?
Well, 2 weeks time.
2 weeks time to file affidavit. Yes, thereafter. Yes. On so and so.
Lordship gives us the date.
Yes, please give him the date.
Hearing.
2nd of August is also.
Item 15.
Okay, general is actually the office appeal. The second appeal.
This is the second appeal.
Actually, my Lord, it's again in this
Not
case,
a second appeal.
Should not be a second appeal. It should be an MAS.
Like the earlier case.
Yes,
that,
earlier cases also. Because second appeal, my Lord, then it becomes because it's not against a decree. It should be MAS.
What's the meat of the matter?
Yes.
You're for the appellant.
My Lord, on 31/3/1992, my Lord,
Yes.
an ex parte
31/3/92.
92, my Lord,
Yes.
an ex parte judgment and decree was given. Yeah.
For the participant Anjali Nongrum.
My Lord, we'll give you a list of dates because it's quite lengthy.
Now what happened? Original appellant died.
Yes, my Lord.
Dan Bahadur Master.
Yes, my Lord. Now, my Lord, that ex parte judgment, my Lord, that is at page 16.
One. Ex parte judgment.
My Lord.
Yes.
And the effective portion is at page 22, my Lord.
Internal page. Or 622.
22.
Yes.
So, my Lord, according the order, my Lord, accordingly it is declared that the defendant has got no right to stay in the house of the plaintiff and to raise any other construction on the land of the plaintiff and to set up any school or any activity there.
Yes.
The permanent injunction is granted against the defendant by restraining the defendant, his agents, servants, associates, or anybody claiming through him from entering into a portion of the land of the plaintiff or raising any construction. The mandatory injunction is granted as prayed for by the plaintiff, directing the defendant, his agents, associates, etc., claiming under him to quit and vacate the house of the plaintiff, also to remove the structure, if any, illegally constructed by the said land. Plaintiff is entitled to the full costs. Now, Lord, this was, as your Lordship has seen, this was on the
20th 12th.
My Lord,
1991.
31st,
No, the order is dated 31st March.
31st March 1992.
Okay. 4 day on top because this title will come. Okay.
All right.
31st. Yes. Ex parte order.
Well, Lord.
Right.
After that, my Lord, nothing happened. It just remained like that. The defendants, continued to remain in possession and enjoying the property.
That means you enjoyed.
My Lord?
Your predecessor's interest.
Yes, my Lord.
Yes.
It continued. So, my Lord, in the year 2002, the defendants came to know about this judgment. Before that, since 1992 till 2002, they were not even aware of this judgment. So, on coming to know about this judgment, an application was filed for setting aside the ex parte judgment, along with an application for...
I mean, you didn't know about it.
We didn't know about it.
And they didn't act upon this order also.
Nobody acted on it.
Okay, yes.
Nobody acted on this judgment, and no execution was filed. Nothing happened. So, my Lord, in 2002, 15th November, my Lord, an application was filed for setting aside.
After 10 years?
My Lord.
Over 10 years.
Now, my Lord, in the meantime, what has happened?
Yes. Yes.
Your Lordship is aware, Millard, in 1992, Reboy not a separate district.
Right.
So
yes.
the
93 it came.
yes. So 1992, Millard, the judgment, the ex parte judgment was in the court here of the assistant to the DC in Shillong. And thereafter,
Where the property is situated?
it's in Reboy, it's in near Khanapara, Millard.
Okay.
Khanapara. There. So, Millard, if I can take your Lordship through this application for
Yes,
setting
where?
aside.
Yes.
Millard, that is at page 24, annexure 2, Millard.
Page 24.
24, Millard.
Okay.
Now, there is a, Millard, as it so happened, Millard, when the ex parte judgment was given, Millard, that time actually the WS was also not filed.
By you?
Millard.
Yes.
What happened, Millard? Anyway, let me take your Lordship through this. This is at page 24, Millard.
Yes.
The setting aside.
Yes.
That I'll take your Lordship through this.
Please, yes.
It's not very long, Millard. Petitioner defendant is the owner in possession of the plot of land at Khanapara within the district Ribhoy, covered by a deed of settlement dated 25/10/59, executed by the Dorbar Ride Marwet Millim, same shape, in favor of the petitioner, which was duly registered with the sub-register Shillong, and the petitioner has all along been paying land revenue to the Ride Marwet. So the petitioner got a cowshed and a residential house, an Assam type house, and an RCC building over the said had constructed. Millard, residence.
Type copy.
Oh, my lord.
What's the figuree?
Sorry, Millard?
What's the figuree? F-I-G-H-E-R-Y.
Sorry.
It's a cross between a fishery and piggery. Figuree. First word. Cattle and figuree.
Sorry. Fishery over the said land.
Fishery or it's a piggery?
Figuree, Millard, but it's written here as figuree. I think it should be a fishery, Millard.
Yes.
Which is the only source of livelihood to the petitioner. Now, our case is that the plaintiff has a land adjacent to the petitioner.
Now, one thing now, see, para 4, you are aware what the ad interim injunction?
My lord.
You
My
are
lord.
aware of it?
My lord.
Okay, yes.
In 1991, there was an ad interim injunction.
Yes.
Now, that was assailed before the High Court, Millard. That was assailed before the High Court. The proceedings were going on in the High Court. Now, that being aggrieved by the said anti-interim injunction, petitioner finally preferred an appeal in the court of the additional deputy commissioner, who, after hearing the parties, upheld the injunction order, and as such, the petitioner was left with no option but to approach the Honourable High Court by way of an appeal. That the Honourable High Court, with an order dated 1996, passed in the miscellaneous appeal, first appeal number so-and-so, directed the trial court to dispose of the suit within a period of 4 months from the date of the order.
Now, stop there. You mean to say when this Mrs. appeal was filed before this court, they entered appearance and contested the matter?
In the High Court?
Not in the High Court.
But that time the suit already been disposed of?
Yes.
Suit has been disposed of.
And this...
My lord, suit has been disposed of by that time.
Curious case.
My
Yes.
lord. My lord.
No, the thing is that who contested it? Who contested the Mrs. appeal, the first Mrs. appeal before the High Court?
My lord, it's not very... My lord...
Is it here, where the order is here?
Order is there, my lord, it will reflect that none appeared for the respondents.
Yes.
High Court was not aware of the disposal.
Exactly. I mean, you're not aware. That shows the fact that you're really not aware.
My
If you
lord.
came 1986 to get an order for disposal of the suit,
My
for the
lord.
suit disposal of 92,
92.
4 years after
But
disposal.
my lord will keep in mind that they were still appearing before the trial court also.
Who?
They.
No, my lord,
Because
the matter went ex parte.
The suit was not stayed.
Okay.
My lord,
Yes. Yes.
so 1996, my lord, was the judgment of the High Court.
Yes.
Now, thereafter, my lord, Khanapara became a separate district, in a separate district. And, my lord, in 1996, my lord, the suit was, there was a direction to dispose of the suit within a period of 4 months. So that direction was to the court of the assistant to the DC. Now, which assistant to DC? That question comes up, my lord. Now, this was, as far as we were concerned, my lord, the matter was from the court of Shillong. So, we were expecting a notice from the jurisdiction at Nongpo.
Yes.
And, my lord, the case record was to be dispatched from the High Court after disposal of the appeal. So, my lord, a notice was called for. Notice, and on making inquiries at Nong also to ascertain the position of the case, my lord, the records were not traced. That is said at para 9, my lord.
Of this application.
Of this application, my lord. Now, my lord, our case is that on 25/10/2002, it came to the knowledge of the petitioner here, that means petitioner's predecessor.
That they existed in ex parte order.
That there exists.
Okay.
So, my lord, immediately after that,
30 days within the knowledge.
within that period, my lord, from the knowledge,
Order 9 Rule 13.
right, 9 Rule 13 has been filed. But, my lord, for abundant caution, an application under Section 5 of the Limitation Act was also filed. Now, since that time, my lord, now we are before your lordship on those applications under.
So since that time, now we're sitting at 24,
My
we're
lord.
still dealing with an application which was filed in 2002.
My lord, it's still going on, my lord. That is what is happening, my lord.
So how do we bring a quietus to the matter? What is the situation on the ground now?
On the ground, my lord, we are in possession.
They're still in possession?
Possession.
A portion, because this is a big land.
A very big land.
In a portion of the.
They settle it with them.
We
Settle
tried.
it with
In
them.
fact,
We
in
were
fact,
trying,
we tried.
Settle it with them. Where are the parties?
Both of us have been trying and trying.
Bring it for mediation. Where the parties? No point. This kind of litigation because it is no point. It is futile. You bring.
In fact, my lord,
Both of us have tried our best.
Mediation, no. It's not gone for mediation. Yeah?
No, not
I think it was just
formal.
for the interest of larger interest of justice. Let you also get some, that. Although we don't balance equities and like but even then, that kind of thing because.
Both my friend and myself, we tried. We tried our best to bring about.
This matter now, see, it's because of circumstances beyond your control also.
My lord.
Like what happened, subsequently.
My lord.
Because you filed your Mrs. Appeal first in 1991.
My lord.
Correct. And then 91, that means in the intervening period, 1992, from what I can see,
My lord,
that order of ex parte order disposing of the suit was filed.
My lord.
Whereby, restraining orders are passed against you and you're not allowed to do whatever in the land.
My
and you
lord.
unaware of it, happily you're going filing, filing before the, after you got order of the court from the High Court, again looking for the records, and finally one fine day you woke up and found out that that is on, he said, on October 20, 2002. That is ex parte order existed.
That is precisely the, my lord, I'll just...
See, if we go back, you see, if we rewind the clock now,
yes,
we allow your application to be reconsidered under Order 9 Rule 13. Right? What will be the, what will be the, what will be the, the outcome now? The suit will take another...
Application under Order 9 Rule 13 took 10 years, my lord. So,
this one
delays 10 years. So the suit would take...
13, now 22 years.
Yes.
It's 24. Exactly. 22 years now.
22.
Now the Order 9 Rule 13 application has to be heard.
22
now
years.
Now it will be reconsidered again. 22 years is gone.
My lord.
Right. Then suppose the suit is restored, the ex parte order is recalled.
My lord.
Now your suit starts afresh. You want to file a statement also.
My lord.
The suit is suited in 1991 or something.
My lord.
So 91 to 24.
My lord.
I think we'll send it for mediation. Can they come?
Yes, yes.
They'll come.
That's up to you, counsel, to explain. Otherwise, if we decide the case, we can easily decide it. I can decide it right now. Like if I don't look into the other aspect. You understood? I've understood the matter. It's
a very, very long pending.
It's pending for too long. It has to end.
Both the lower courts also, my lord, actually this paragraph 11, which my friend was reading,
yes,
that is crucial for the case. That on 25/10/02, the petitioner was called by the officer in charge, Khanapara Police Station, in connection with a case in which an FIR was lodged.
That is why they learn about it.
That is their claim. My lord, they have never annexed a copy of the FIR with this application. So what the trial court had done, they called for she called for a report from the OC. And the OC came before the court and said, no, there is no such FIR. So the crux of the matter is whether they have made false statement in the application, which both the trial court as well as the appellate court also came to a finding and said yes.
Where's the order you appeal against? Let's see the order.
Page 80.
Yes, let's just read that at least. Where the finding?
Shall I take your lordship through the whole order? Findings, my lord.
Page 88 onwards. Third paragraph.
Yes.
This court shall examine the facts.
So should we go for mediation first? Yeah. My lord, as my lord suggested that we should go for mediation first, let us try once more.
If there is a mediation at the initiative of the Honourable Court, then...
Mediation by the High Court, yes. I mean, we'll send it for mediation.
Because both the lower courts have stated that on they had appeared before the trial court. Even after filing of the revision petition before the High Court, they appeared on 2 occasions before the trial court.
This is found the single lapse on the part of appellant and failing to make appearance trial court has posted matters on how the appellant failed to make appearance for has never been unambiguously explained. What does it mean?
Language. Para 19. Page 90 is important.
Because it's just looking at largest. Otherwise, on facts, I think, You'll agree for mediation because you are the one having upper hand here.
Yes. We are agreeable, my lord. In fact, as I said, as my friend said, we
Since
tried.
your continued occupation for how many years? Yes, this appeal. First, we'll change it.
Yes, to MAS.
This appeal will be styled as a second appeal. Stop.
It was converted into a second appeal.
By this court?
My lord, because initially it was not filed. It was filed as
It doesn't matter. Yes.
It doesn't matter.
Yes, only in the course of hearing, it appears that the case being of a considerable vintage, which has commenced from 1981, for the ends of justice, perhaps the same be sent for mediation to attempt a settlement between the parties. The proposal of the court is concurred to by the learned senior counsel for both the parties. Accordingly, place this matter before the mediation committee of this court for necessary action. They'll issue notices.
Yes.
Otherwise, only thing that you've been in possession for, if you're out of possession, that'll be different. But in possession, if that is they also they admit it, since.
No, my lord, because we filed an execution also. 12 years is the upper limit. We file execution on a 10th year. They cannot take.
Yes.
16. 16.
Much obliged.
Obligement.
What's the matter about?
Relating to payment of
pension.
Yes, Lordship.
This is that the person died.
Yes, Lordship, and the wife has substituted.
And there's some dispute proceeding against him.
Yes, Lordship.
That is over.
That is over, and then the appeal also disposed
there
of.
was another.
Appeal was there. Appeal also disposed of, upholding the order of the disciplinary authority.
In your favor?
Not in my favor, against me.
You've challenged that?
Yes, Lordship. In this.
What happened to that case?
No, that is also pending. Those two.
Tagged together?
Tagged together.
Two matters?
Yes, two matters are there.
Yes.
So, Lordship, here the petitioner was initially.
Long IT should be here. Tissue mới thể đọc là cũng có thể đọc thân được. One second. Số thu tố là số thu này def. Số thu thế. Số thu. Hold on. Oh, yes.
Lordship, petitioner was initially appointed temporarily in the post, vacant post, grade 3 of range assistant, as a range assistant in the office of the divisional forest officer, Garwell's division. That was by annexure 1, page number 14. This is the office order number 82, dated 21st February 1986. His name is reflected at serial number 3.
Yes, okay.
Thereafter, by office order number 19, page number 16, that is dated 15 January 1993.
15. Page?
Page 16.
Yes.
That was issued from the office of the Principal Chief Conservator of Forest, Shillong. Office order number 19, dated 15 January 1993. The following officiating incumbents are substantively appointed as permanent LDS RS with effect from the date and against the vacancy indicated against each, sanctioned by government letter number so and so. So here the petitioner's name is reflected at serial number 56, page number 20.
Yes.
And his post was confirmed as RA against the permanent post with effect from 8/1/1991.
Where you get it from?
Page number 20.
Okay. Confirmed as RA means?
RA means range assistant.
Okay. Is equivalent to LDA?
Yes. And there is no break of service. He continued, and on 15/10/2019, sorry, 15/10/2019, that is from the pleadings, that there was an FIR against him, alleging that he had done forgery.
15/10/2019. FIR against you?
FIR against.
Yes.
Alleging that forgery of check, and thereafter the William Nagar police has registered a case, William Nagar PS case number 39 of 10 of 2019 under section 468, 71, 471, and thereafter, Lordship, DP was conducted against him, and the DP has concluded in
this is regarding DP. This person is regarding DP. This one was the pre in this writ petition.
In this writ petition, Lordship, for payment of
pensionary benefits, okay.
Pensionary benefits,
this one,
and
is
for
WPC
disposal
number.
of the.
Let me just segregate this. All I understand. This is WPC number 494.
494. This is 494.
494 is for pension. Okay. Plus. Okay. Then, and the other one is?
Other one is for quashing of this.
WPC one number?
WPC number 208.
208 of?
2021. 22, sorry.
DP, okay. Okay, carry on. Yes. Yes.
So here in this writ petition, the prayer is threefold. That is, one is for release forthwith pensionary benefits to the petitioner, including pension. And number C is disposal of the statutory appeal filed by the petitioner on 36/2021. So this prayer does not survive because the statutory appeal has been disposed of, and then subsequently the WPC number 208/2022 had been filed. So this is the case in brief of the petitioner. Now, what has been contended by the respondent?
Why have they denied you?
Yes, their main contention is that the service is ad hoc. Ad hoc.
Where is that?
That is in their.
You have impugned that.
No, that they have taken a plea now in their affidavit in opposition.
What are punishment inflicted upon you on the DP?
Withhold of 2 increments.
Yes.
Withhold of 2 increments and recovery of 5.21 lakh rupees.
That's been recovered?
Till now, no, Lordship. That has not been recovered.
Yes.
And that is from the, it shall be recovered from the GPF, balance 30%, area pay and retirement benefits.
Okay, let's continue with the
Yes.
first case. I was just asking. Yes, now what happened?
Now,
what is the stand of the...
Stand of the respondent is that the appointment is ad hoc appointment and he cannot claim for retirement and all.
Yes.
Now, and further, that the 3 ACP, which the government employee is entitled after 10 years, 20 years of, and 30 years of service, those were also denied to him.
Now the stand is not a regular employee at all.
No, Lordship.
That is ad hoc and you continue as such until you appoint 86.
86.
So that means
Confirmed
they
in
say that
91.
you never regularized
Yes.
as a range assistant.
Yes.
And 15193 has no meaning. LDAs, you appear as number 56, confirmed as a range assistant. Confirmed.
Confirmed.
That orders their confirmation. Order.
Yes,
That's the
Lordship,
order.
that is there.
Okay.
That is their
What
annexure.
the affidavit?
Their affidavit, Lordship.
Yes. Oh, yet to be regularized?
Yes, Lordship. They are para 9 of their affidavit. They have taken a ground that the petitioner is an ad hoc employee and regularization of service is
Then they
still
should
under
related-
examination.
related to regularize the services post facto. They have regularized him. It's 86 and appointed.
Lordship.
Yes. Mr. Abraham, sleeping.
Let him complete the
It
submission.
only comes, there's nothing else in the case. He was appointed 86 as range assistant. He was confirmed 5293 with LDA and confirmed the post of range assistant. FIR filed against him in 2019, and then the proceedings, he's been awarded some major punishment. Now you say that he's not a regular employee. So what do you do in that case?
What happened is that with regard to regularization, I think the government has passed an order regularizing his service.
Is regularized?
Yes, Lordship.
Then nothing remains here. What about his
That-
MSCPS?
Now, what happened is that those 2 penalties, which he was found, he has withdrawn
Okay.
government money by
Okay,
forging the
fine. He's been found guilty. Charges proven. Appeal dismissed. His appeal dismissed. Right.
Yes, Lordship.
Now he's been asked to advance 2 increments.
2 increments in this
Yeah, okay.
writ petition.
That's major, and then to refund 5 lakh
5.21.
Okay, 5.2. You adjust it. You pay his pension, his wife's pension, whatever. Adjust the amounts due if you're regularizing him, because you confirmed him in 93. Confirmation can't be regularization. Confirmation follows regularization. And so you already confirmed him in service. What are regularizing him in 93? Correct? Yes. Now where's the order of regularization?
Order of regularization.
I was just, if this matter may be taken up after some time.
After 5 minutes?
After 5 minutes, yes, Lordship. Another matter may be taken up first, yes. Then
I don't understand what you're saying, Mr. Abraham.
because this matter has been led by AG, so he's unlike before Supreme Court. So if this matter...
This matter after 1 week.
Yes, Lord.
But that's the mind of the court. And what about what happened to this proceeding? You're asking for it to be overturned. Let's take out this. See the other matter first.
Other matter, yes.
This matter, okay, we'll put it. We can segregate it also. Because whatever happens, no need to take so long. These matters actually. They're all 5 minutes. 5-minute matters. Yes. Yes. What's the ground? What's the ground for challenge?
Lordship, they are a violation of principle of natural justice and the rules.
Which we were not given adequate opportunity.
Lordship, we were not given adequate opportunity, and that on the day when Shokos was, notice was issued, on the same day the enquiry officer and presenting officer has been appointed.
So you file show cause as to whether why DP should not be drawn up.
Yes, Lordship.
But the charge is so serious. There's no question of any show cause saying that, okay, fine, we won't draw up DP.
Then
that's just a small irregularity, will not affect the outcome of the proceedings. Yes, next.
Next is, Lordship, that the evidence and the materials against which has to be used against me, Lordship, that were not supplied. And for that, I have filed an RTI, and after RTI, only the inquiry report was furnished, but not the statement of the witnesses. And based on that, only I have filed the appeal.
What will happen to criminal case?
Criminal case has been ended in FR. That has been also been brought in by an affidavit. And to that, the officials were given a notice, and they have accepted it before the court.
You have not filed any objection?
No objection. They have accepted it. Lordship,
1 second. You cross-examine the witnesses. We're allowed to cross-examine the witnesses.
Lordship,
we are allowed or not?
They do have to.
You have to what? See, the disciplinary proceedings and criminal trials are on two different footings altogether.
Are two different,
The
but
standard
if
of
the
standard of proof for department proceedings are low, while for criminal proceedings is beyond reasonable doubt. Right? If the court sees that the proceedings have been regular, you've not been denied materials, and you've cross-examined the witnesses against you on the basis of materials
those proceeding was behind my back. That is my pleadings.
You have to show that behind your back that the violation has vitiated an inquiry.
Yes,
that
Lordship,
demands for the
that was
inquiry won't be feasible now
and
because he's dead.
The entire record has been called by your Lordship last occasion.
We will hear after 1 week then.
Lordship.
You please prepare. You just
And this,
what was your stand
this,
in the proceedings?
application was filed.
This after 1 week, yes. Why are we just conducting this matter? It's of such importance.
The MSCP and ACP matter for that, because he is claiming that will have a large impact.
Large impact on what?
That all those similar employees will come up forward.
No, you are different. You had DP against you. Yes. Yes.
My lord, this is a case that Home Guards regarding the revision of pay, Lordship, the benefit of 5th Commission, Lordship.
Those,
yeah, Lordship.
Home Guards.
Yes, Lordship. What happened? My lord have heard the matter, and
when
I have relied the answering judgment, and answering judgment has squarely covered this case, Lordship. Now my lord have asked the state to have instruction whether that judgment has been
implemented,
challenged or not, or implemented.
Yes, Mr. Abraham.
Lordship, in that case, that judgment, if I have referred on last occasion, what happened that the judgment, the petitioner, they were enjoined third pay commission, and all of a sudden the pay has been stopped. For that reason, they have been asked to pay the fourth pay commission. But in the instant case, there's no instance where this petitioner has been enjoined third pay commission or fourth pay commission. So this is the case, and the petitioner has been already disengaged in the year 2012 December. So I don't think even if he is successful in the revision paper, they have been disengaged because the service of the petitioner valid so long, the requisition authority.
You've been disengaged since 2012?
In
2022.
22 December, Lordship. My revision of pay is due from 1st of January 2017.
No, please distinguish. How did you say that? Now you say that this this judgment, he says, covers his case, correct? And the instructions you suppose receive is whether, how is this case different from their case? How is this case, this Gulab Sena Sinha, how is it different from the case of the petitioners? No, Mr. Abraham, for you to answer.
Oh, Your Lordship.
Why you want to sit down?
If I'm pleased to take Your Lordship to, that is page para 15 of the judgment.
Now, has the judgment been implemented?
With regard to those persons who has come before this court, it has been. But the case of the petition, in that case, that they were enjoying this third pay commission.
No. Come to, okay, para 15.
Para 15, yes, Lordship.
So read it.
Para 15, and the most important is para 18 and 19, Your Lordship.
Read para 15, what does it say?
Since it is the order of appointment which is the primary source of determination of the nature of employment of the petitioner, let us take note of the order of appointment of the petitioner in order to understand as to what were the term and condition of employment of the petitioners. Consider the fact that the order letter of appointment of the petitioner are same on one of such letters, namely the letter number such and such of 9, subject to discharge without notice and without assigning any reason thereof. Three such and such, such and such, such and such. This such and such, the appointment are against the requirement of AG office, Shillong, and will remain valid as long as the requisitioning authority concerned requires the service of the Meghalaya Home Guard volunteer. Should their service be no longer required, no claim or absorption of any of the unit of the Home Guard civil defense will be entertained. Then, if I'm pleased to take Your Lordship to para 19th. Paragraph 19th.
Okay, fine. Their appointment was same. Were their appointment contingent on these three things? That first, the appointment is what? Is on contract.
Yes.
Right.
Yes.
Number two is contingent upon the requirement of the agency asking for them.
Yes, Your Lordship.
And third, that they suppose there's no more further requirement, they cannot, they have no claim to be absorbed to the Home Guards. Is it correct? Is this the three parameters?
Yes.
Okay, what does 19 say?
Yeah. Then the appointment, if I'm pleased to take again back to para 2 of the said judgment, the same judgment.
Para 2?
Para 2, yes.
Okay.
Last line, in response thereof, the Commandant Home Guard East Khasi Hill District, Shillong, issued a letter dated such and such, wherein the statement showing revised pay scale was furnished. The statement read as under.
Wait, I've lost. Where are you reading?
Para 2, the last paragraph, yes. Page.
I've heard so-and-so, ND Chulai.
Paragraph 2 of the said judgment.
Start from where?
Paragraph 2 of the said judgment.
In a nutshell?
Yes.
Okay. Which part are you reading?
The revised pay scale. Revised scale. The revised scale is this. They have shown this 2650 to 50 2950 EB 60. That's 3430. That's 704134. This is the revised
pay. What are you reading this for?
And the pay of the petitioner in this case, if I'm pleased to take a Lordship to you, that I'm in the this pay revision is 220. The revision pay of the appointment, if I'm pleased to take your Lordship to, this is WPC 220 of 2023.
In 37 also.
No, you're reading the judgment. Please continue the judgment, because court wants to know what he implemented, how do you distinguish this, the people here in the judgment from the service of the people, of the petitioners. Because if this has been implemented, what is the operative part here? Implemented, correct? Allowed the revised pay scale. If they're different, then how?
My content is that they never enjoy this third pay commission or fourth pay commission. So how can they be entitled to get the fifth pay commission when they have not enjoying the pay of the third pay commission and fourth pay commission? These are the people they were, because at the initial state of appointment they were enjoying this third pay commission, and all of a sudden they have been denied of third pay commission. For that they have come to the court. The court has given direction, since they were enjoying third pay commission, they should be entitled to get a fourth pay commission. That is the case in this entire petition. This judgment.
Okay, so the case differs in the sense that they never enjoyed any. Now, when the rates were revised by the parent department, they enjoyed that, right?
Till fourth pay commission.
Because if I'm pleased to take a look, but no annexure does to substantiate the claim that they were.
No annexure?
No, there's no annexure showing that they were enjoined the third pay or fourth pay commission, Your Lordship.
You're trying to confuse the court, you succeeded. Yes. You don't understand. Now, come, what 220 you want to show? You just want to see how different is it. That's all. If you're allowed to, we are bound by, judicial discipline.
My lord, there is no difference.
We are bound by the early judgment of the
If
court.
my lord quickly respond, lordship. They have misinterpreted the order of that Gram Suraksha, that judgment, lordship, in 2016. In that judgment, lordship, so far as the regularization is concerned, court has rejected the prayer, lordship. Now that judgment they have interpreted, lordship, because as per the direction of this honorable court, the government has filed the instruction, lordship. In the instruction, lordship, I'll just read, lordship, promptly. It may further be mentioned that the state government, while examining the applicability of the Fifth Pay Commission to the Home Guards, volunteers deployed with the State Forest Department, stated that since the nature of their service is voluntary and also since the Honorable Supreme Court, in its latest order, has rejected the petition of the Home Guards volunteers in the state of Himachal Pradesh, Punjab and Delhi for regularization of their service. Therefore, the recommendation of the Fifth Pay Commission does not apply to them. Now, by this, it is understood that the Home Guards volunteers deployed with any agency being volunteers do not fall within the purview of the Fifth Pay Commission. The ground, that judgment of the Supreme Court, totally different, lordship. Now, what happened after 2016, lordship? The state of Odisha, lordship, relying on that judgment, lordship, they filed a writ. And apart from, they claim for the benefit of 7th Pay Commission. Writ was allowed. Then state filed appeal. Appellate court has modified only with regard to the period, lordship. The single bench has directed from 2016.
Okay.
But the appellate court has modified that it should be 2020. So far as the direction with regard to the benefit of the pay commission
Does not touch.
does not touch. Now against that order, lordship, both the state as well as the writ petitioners went to the Supreme Court. And Supreme Court again only with regard to the period has modified. Supreme Court has modified saying that it should be 18 because lots of financial implication will be there. So neither the Supreme Court has acted on the judgment passed by the single bench as well as division bench, but modified to the extent that it should be only 18. Now I am relying that judgment also. That judgment also says that they are entitled to get the benefit of the pay.
No, the case is that you never enjoyed the third or fourth pay commission. How come you're claiming fifth pay commission?
Oh, that is.
That's what we wanted to show, distinguish, because yes.
My lord, only the thing he says that since I have not enclosed, now the earlier round of litigation with the Gulab Sinha, they have come against the denial of benefit of fourth pay commission. Fourth pay commission.
That answers judgment.
Yes, lordship.
This 2023 was placed by you, Prakash Kumar Jana.
I place, lordship. That judgment I am talking about, lordship. Now this is latest.
What do you want to show him 220?
We have disengaged them. That, if I'm pleased to take, that is the writ petition, the own documents of the writ petitioner. If I'm pleased to take your lordship to page 36, annexure 9. Page 36, annexure 9.
Yes.
If I'm pleased to read your lordship. In inviting a reference to the subject cited above, enclosed, please find here with copy of letter number mentioned above at serial number such and such, as received from the executive engineer PHE such and such Jawai, along with the statement showing the detailed report of Home Guards volunteers engaged in the office of the executive engineer PHE such and such. In this connection, as per the term and agreement for engagement of home guards, volunteers with requisitioning agency forwarded by your office, white letter number such and such and such, at point number 9, any requisitioning agency intending to discontinue their relationship with the department by totally disengaging the service of the home guard volunteers will have to give a 30 days period notice to the department. Therefore, in this matter, it is to inform that the service of the concerned home guard personnel may kindly be discontinued. That is the letter number 1st December 2022. Then, if I please take page 37, Annexure 10, letter dated 19 June 2023. With reference to the subject cited, I am to inform you that your engagement for duty as home guards volunteers with Rural Water Supply Division PHE Jawa has been discontinued by the Office of the Chief Engineer PHE Meghalaya Shillong white letter number such and such, and the same has been communicated to you on 19/12/2022 when you visited my chamber seeking for clarification on this matter. The letter from the Chief Executive Engineer was read and also physically shown and explained to you in the language you understood. Secondly, since your service has been discontinued since the end of December 2022 and you have not been engaged with any duties with PHE from the month of January 2023 onward, the salary can no longer be paid. We have given them notice, that is the 1 month notice before disengaging their home guards.
One thing, Mr. Ibrahim, would come 14A of this 14A of this petition 220, page 14, bracket small a, typed copy.
Yes, Lordship. The following guardsmen are hereby allowed to raise their pay scale to this such to.
So this is against this is as which pay commission recommendation is this one?
This is 1999. This will be not actually pay, but they have been because what happened that pay scale is that they have to be given initially they were one day they were given 300 something plus, but after that the revision pay, the pay has been increased to 500 or 400 something. Is to take.
A letter of appointment only, it's only this one, Mr. Sheikh. Only that is order 86 order. That's it.
Order, Lordship.
1986 order is the only order of appointment you have.
After that, the second revision of pay is there, Lordship.
No, forget revision of pay. I'm talking about your engagement in terms of engagement only as per the requisitioning authority, correct?
Yes, Lordship.
And you given 30 days notice before you were terminated.
My Lord will kindly appreciate one thing.
That I appreciate many things, but were you given 30 days notice or not?
No, that notice was not given. That is why I have challenged in the second writ petition. That will come later, Lordship. The legality and illegality, Lordship. No notice was given. That too also, Lordship, my Lord may recollect, my Lordship has directed that because I have raised the objection that they were not, I was not giving the salary, Lordship. Then court has directed to give the salary if I am working. Then after that, Lordship, what happened? They have issued a letter saying that your service has been disengaged by the requisitioning authority. This is a communication letter, Lordship. That I'll come later. Now this is so far till the time I have been disengaged, Lordship. At least I should pay the benefits of the pay revision. Now his counter, Lordship, what my friend is saying that I was not given the benefit of third and fourth. His counter will reveal.
No, that's what the court is looking for. Where is that, material to show that you have paid third and fourth pay commission scale? I'm asking what scale is this that you have paid 99?
After that,
where is that statement? Where is that document to show that?
My Lord, in the appointment letter itself says that as admissible, pay, scale of pay.
Where's the to show that you have paid at the scale of pay of enjoyed third and fourth pay?
That is, Lordship, that is inadvertent, Lordship, that is the internal communication between the department, Lordship. Now, my Lord...
Now, if Home Guards or department fix, you'll see as per revision recommendations of the pay commission.
My Lord,
people are being allowed the revised pay as per revision of pay rules, so and so.
His counter, Lordship, his counter will reveal. His counter will reveal. Because when I raised the objection saying that...
Because it comes like this, it's very simple. once a pay commission recommendations are given, doesn't mean that the government accepts everything.
Yes, true.
Then whatever they accept, it's adapted, amended to the revision of pay rules.
Yes.
Right. It's amended to revision of pay rules, whatever is applicable to you. Now, whether you pay revised pay in every instance that there was a pay commission recommendation, that we have to see. You understand? So even for your limited right, you say that till you disengage, you have to be paid. Now the court has to come to a clear understanding as to on what basis we have to allow your prayer. That's all.
Lordship.
And then if Mr. Abraham, he says, please distinguish the judgment of that case. He says that fine, there's nowhere being shown there, and these people were being paid they're being paid as scale on the third pay commission.
Fourth,
whatever. No. In Justice Ansari's case.
Fourth.
They were being paid fourth. And so entitled for fifth.
Because they were denied fourth pay commission.
Help the court to come to a conclusion.
My lord, his counter lordship, para 7. They have specifically, it is not said that I was not given the benefit
counter
of.
Where?
In 37 lordship.
Are you just running around circles? Counter in WC 37. Okay. Let's see what they say. I haven't seen any material to show that, to clearly say that yes, Mr. Sheikh's clients were paid the fourth and the revised pay as per recommendation of the fourth
My
pay
lord
commission.
is correct.
That's what I can't see.
My friend is raising.
Why submitting? I'm trying to look myself.
Yes, lordship. I have enclosed only the appointment as well as the second benefit of the pay commission. Third and fourth, because that maybe that order was not available with me, that is why. Because when they have denied the fifth commission, then I approach. Otherwise, had there been an occasion for denial of third.
Can we go on conjectures and surmises?
My lord, I'll just read the counter affidavit of the government lordship.
Okay, which paragraph? Otherwise, you're not getting anywhere.
Yes, lordship. I'll just read from paragraph 7, lordship. With regard to the appointment made in para 4 of the writ petition, the answering deponent states that the annexure 3, that is my appointment order, was not.
Which paragraph are you reading? 7.
7, lordship.
Yes, that with regard to appointment, that necessity was not issued by Office Respondent 4.
3, that is the second revision of pay benefit, lordship, was not issued by the office of the respondent number 4. But in fact, it is the office of the respondent number 5, that is the Home Guards, who has issued the same and the copy of same given to the respondent number 4. As respondent number 4 is just the paying authority, and whatever funds has been allotted to the respondent number by the on behalf of the respondent number 1 to 4, respondent number 4 has released it to them. It is pertinent to point out that whenever there is a revise in the pay of the petitioners, it is the respondent number 5 who issued an official order communicating to the respondent number 4, as it is evident as per the annexure 3 of the writ petition. As such, the revised pay of the petitioner has not been revised after 2016, as there was no official. After 2016. Next para, I have pleaded that till 17 I was receiving. Now what was the response, lordship? With regard to the abatement made in paragraph 5 of the writ petition, the answering deponent states that it is pertinent to point out that the petitioners are not government employees. That is, I am not disputing. And in fact, they are Home Guards volunteers, and their appointment is a guardsman in the office of respondent number 4. But in no way they can be termed as government employees, as they have been engaged on a temporary basis, and further their appointment was made by the office of the respondent number 5 as per annexure 1 of the writ petition. As such, the demand of for raising of pay.
Has Home Guards filed an affidavit?
Home Guards did not file the affidavit.
Why?
But place on records some instruction.
Please to take your lordship that Home Guard that affidavit filed by on behalf of respondent number 5 as per order dated 21/9/2022. That is
on record. It's not here on record. I see only one affidavit.
WPC in WPC 220 of 2023.
I affidavit 220. RP Khongwar.
Yes, your lordship.
Para 910 is very clear.
Yes, if there's admission, then we'll...
Very clear.
Where 910? In this affidavit?
In the affidavit of 37, Lordship, not...
No, he's saying,
Yes,
think,
Lordship.
where is the... See, what he's submitting, you understand? He's saying that that pay scale is been given by the Home Guards, which you in PHE just follow. You're the requiring agency, you have taken the services of these petitioners, you're paying them a scale of pay which is given by the Home Guards.
Yes,
Now that is why now they don't have any papers to show that we've ever paid at the not that paid at fourth pay. They're paying the as per the fourth pay commission. Correct.
Yes,
He's putting the onus on you that is the Home Guard that and even the PHE said is the Home Guard recommended the pay scale. Now where's that?
My Lord will his affidavit file in 220,
Yes,
Lordship.
where's that?
Yes, Lordship. 6.
Otherwise,
Para 6, Lordship. Roman para 6. Roman para 6, Lordship.
so nothing.
That is why I have said, Lordship, because they have misinterpreted the order of Supreme Court. But Supreme Court did not say with regard to the revision of pay. Supreme Court says that
What
super
does the stamp of Home Guard say? You're paying for them also.
Yes, Your Lordship. That
Yes.
I have been asked as
Were
part-
they ever, only question is, were they ever afforded a pay scale under the revision of pay rules, which is on the recommendation of the Fourth Pay Commission?
No, Your Lordship.
Where's that?
We have not taken the specific.
See, the thing is that the matter is not very complicated. The only claims that fine, like I said, the three grounds as appointments, right? First, voluntary is temporary, is on contract. Second, it is contingent upon requirement of the requiring agency.
Yes, sir.
Correct. And they will have no claim to continuous employment if the requiring agency does not require them anymore. Now, what's the case in short? The case in short is that we were enjoying a pay under the Third Pay Commission and Fourth Pay Commission, right? Now, when they saw they were not getting the Fifth Pay revision, as per the Fifth Pay Commission, they have gone and represented. Now the services have been disengaged from 2022. Right. Now it is saying that since now give us our dues. Give us our dues, and our dues should be the dues which are to be computed to be paid under the Fifth Pay Commission. That's all. Now what's your stand? Now they cannot make any quarrel about their continuing in employment because this is over. Maybe only with the regard of service notice they have not got those 3 days. Maybe they might have some grounds with that. But that doesn't mean that it cannot be compensated with, a month's salary, something like that. That can be adjusted. The only thing is that now, where is the paper to show that they were enjoying that Fourth Pay Commission? That's the only thing. I've tried to look myself. I can't find it here.
My Lord, para 6, Lordship.
Para 6 doesn't say anything.
Para 6, that
para
is
6
why
you go to, it goes to, it's not entitled.
Fifth Pay
Where
Commission.
were you, where is
No,
a
they
document?
said that Fifth Pay Commission is not
you
entitled.
show that you were paid the pay scale as recommended by the Fourth Pay Commission to entitle you to revise pay.
My Lord will kindly appreciate. Para 6 say.
I feel I'm talking to stone wall here.
Yes, Lordship.
Yes, fine.
Now this is internal document, Lordship. When the pay scales are revised, the employees hardly get the copy of the order sheet, Lordship.
That is why we're asking the whole
Yes,
class.
Lordship.
And that's why last time the hearing was there, I remember that this judgment is there. Have you implemented it? And you said that it's implemented because these people were enjoying the Third and Fourth Pay Commission recommendations. Now the only question is, were they enjoying it or not?
That's what.
And that now we can't get any answer.
The query from this
They
honourable
have to
court
make out
whether
they have to stand on their own foot. You see,
whether
not
they have
on the
challenged
witness
that-
of the respondent.
They have to stand on whose foot or on foot?
They have to make on their own merit, not on the weakness of the respondent, Your Lordship.
Please come up with the materials. You're the one who's prescribing the pay scale.
You say that because they have not enjoyed the pay scale, so we don't have any document to show
Only
that.
thing is they don't enjoy it, that's all.
No, Your Lordship.
Fine.
the specific query from this honourable court was when I have relied that judgment that whether any challenge has been made by the state government or not. That was the specific query.
And whether you implemented it or not.
That was the specific query, Lordship. Now, my
And
friend,
again, second hearing we're having, again, we're coming back to square one and swimming around in circles like this.
Even otherwise, Lordship, even otherwise. That Jana judgment, in pursuance of the Jana judgment, in relying the Jana, yes, still I am entitled for the benefit of.
See, Mr. Sheikh, the court wants to at least be clear.
True.
Giving you the benefit of a
Yes.
judgment of the court, fine.
Yes.
But then it has to be clear,
Clear.
as to the facts of your case.
True.
We're not even on law.
Yes, Lordship.
That is the sad part. Like I keep on saying that law follows the facts. When the facts are over, then we apply the law to see how your rights have been violated.
Now in
how did we get
that
redressed?
state
Now
respect-
we haven't come to the law, so we're just swimming around in facts.
My lord can direct the respondent to place the revision of pay, with regard to like every 10 years they used to
With
fix
records.
Because it's not record. There's no record also, Your Lordship, with me. But since Your Lordship has already heard the matter, because they are only now harping on the.
Don't say that you heard the matter. Kindly pass any order as you seem deemed fit and proper.
They are just harping on the Fifth Pay Commission. The Fifth Pay Commission.
See, let's not swim in the same place again. They don't know what is matter. We can't get any. We understand that you have denied that you won't be entitled to fifth pay, but he is maintaining that he was paid fourth pay, so he'll be entitled to revision of pay.
Let him show that he was enjoined this Fourth Pay Commission. Then he will have a case. But at no point of time he was enjoined the Fourth Pay Commission. Then if he was not enjoined the Fourth Pay Commission, how one fine morning he is entitled to get a Fifth Pay Commission by overlapping this Fourth Pay Commission?
By citing the judgment he's placed. That's why this is the difficulty.
That is the different case for different people.
These are the all home guards. Their appointment terms and condition is same.
Yes.
Same.
Appointment, even this pay scales are totally different, Your Lordship. That's why I wanted to point out at the initial state of my argument.
That was after revision. That was not the initial pay. They were appointed in 1988. What my friend was referring, that is 1998, after 10 years of revision.
Because even your order of appointment was very vague. That's the only thing, Mr. Sheikh.
My lord, plus other allowances as admissible under the Meghalaya Revision of Pay Rules 1980. And other as per the revision of pay, whatever the entitlement I should get. Now, second revision of pay, Lordship. That is at page 3.
I'll just, 1 second, let me just. Because you can't deny the fact that they were appointed regular time scale. So we only have to see what scale were they up before they served disengaged, what scale were they paid. That's the only thing. You don't have that also.
Yeah, I don't have.
Then that's why he's very cleverly saying, don't go on my weakness, bring forth your own case.
Lordship, people used to come to the court when some right has been violated.
Of course.
Yes,
Don't
Lordship.
come to court for fun.
Yes, Lordship, true.
See, Mr. Sheikh, I won't stop talking also. I don't like arguing with the counsels. The thing is, where's your appointment letter? This will start from there. Then we will unravel your case. In 220 or 37? Where's your appointment?
37, page 11, Lordship, in 37.
Yeah, page 11.
11.
Yes. So we are paid in a regular time scale?
Yes.
Yes, as per Revision of Pay of Rules 1980. So, Mr. Abraham, when they were appointed, the promise of appointment was that they are on a regular time scale, correct? Three conditions are there, okay, fine. Contractual requirement of the requiring agency, and now we pay it in the regular time scale, okay? Now, once you pay the time scale, as per revision of pay rules 1980, shouldn't that follow consistently when the pay gets revised again? It's not, they're not paid a consolidated pay. Try to understand that, okay? Now, only gap is that they cannot show that they were given benefit of the third and fourth pay commission. That's the only thing.
Yes,
but can the in your by what okay by do you think the court can by itself exercise decision and say yes, since they were appointed in a regular time scale, that same will continue, and if they were the service discontinued in 2022, when the revision of pay rules were revised as per the fifth pay commission, they'll be entitled to pay under the fifth pay commission. Can we say that?
But this, as your Lordship knows very well, that the pay commission recommendation, it is up to the department whether to be to implement.
Please don't make the argument. I'm not saying you're not coming with any materials. After article appear, we're not getting anywhere. The court's only saying that suppose you're upon a real time scale under revision of pay rules of certain year, right?
Yes, Your Lordship.
Now, once you enter employment, till it ends. Now, the promise is there that you are being paid regular time scale on the revision of pay rules. And revision of pay rules come when they come on recommendations of the pay commission. Correct? So, subsequently, okay, they paid third, fourth, then third comes. Third, now whether your pay, he said pay is revised accordingly, he was paid as per the third pay commission. Now the gap is there, whether he was paid as a fourth pay commission or not. How do you pay them? You are paying for both PHE and for the home guards. So that's why this court saying whether we can take it to be a continuous process that they were paid, as per the revision came, they were paid that revision of pay, the pay was revised.
My lord, that is the interpretation of Ansari judgment, Lordship. That is also my lordship's.
That's
getting very difficult.
They cannot unilaterally change the conditions.
Yes, Your Lordship.
No, once you are appointed on the
Yes,
regular,
they can.
see, if you are consolidated pay. If you are appointed on the regular time scale, it's expected that that will continue, right? You cross efficiency bars, then the scale goes on, correct?
Yes, Your Lordship. If I'm pleased to take Your Lordship to in that 220 of 2023, affidavit filed by respondent number 5 as per the order dated 21/9/2023. That is page 15, annexure the page annexure 5. If I'm pleased to take Your Lordship to page 15, annexure 5. Page 15, annexure 5.
Getting tired, just a lot of time wasted in this case. Well, Mr. Shulai, he appears matter, I think, in the earlier round.
Page 15, annexure 5, Your Lordship. Order dated 20th September 2019. 20th September 2019. If I'm pleased to read, Your Lordship, in pursuance to the Department Notification Data such and such of 2019, I'm directed to convey the approval of the Governor of Meghalaya to the...
What's duty allowance? Is that pay? You call Mr. Shulai.
No, Your Lordship, then
you tell court notes that situation assistance is not forthcoming from the government advocate. Either Advocate General or Advocate General requested to appear in the matter. Otherwise, you're not getting anywhere. And the case being stuck up for nothing. Whether you have a good case or a bad case, so you don't know.
20.
I'm very sorry, I don't want to make this observation, but if it's not getting anywhere.
Whatever due they are entitled, they'll get it. But
what dues are they getting? That's what we want to know. That's all, Mr. Abraham. How more can a court make you understand? That's the only thing. What dues are they getting? How were they paid? What is the scale they were paid? That's all. What was the PHE doing? What scale were they paying them before they were disengaged? That's all. Simple. It's not nowhere in the thing. Mr. Shulai, you kindly, sorry to ask for assistance, but in this matter, I think you better just take up the matter because you had argued similar matters before. He'll brief you. he's tried to do a good job, but then there's some lacuna in the affidavits and the materials that have been brought before the court.
Lordship, let me
You can
have a look.
20.
Apply, Your Lordship. You give me the file.
May I please, Your Lordship?
Yes.
My Lord, on the last day, that is on 4th July, my Lord has given me time to compute the amount payable to the writ petitioner, my Lord. My Lord, and if I may draw my Lord's attention to the order dated 20th of May, my Lord, where we have said that we will be able to pay 5,000 per month, my Lord. And subsequently also, my Lord, we have reiterated on 7th June, my Lord, where we said that we will be able to pay 5,000 from 2022, because her claim is from April 2022, that was the last, 2020, that was the last that she received the payment. And during the course of the proceedings, my Lord, we have paid to her, my Lord, 4,80,000, my Lord. That is from May 2020 till
December 2022.
December 22, my Lord. December 2022, my Lord. Now, my Lord, since we have subject to what my Lord would say, my Lord, so now when we calculate 5,000 rupees, my Lord, for 51 months, that is the due. We are calculating till July, my Lord, July of this month, my Lord. We are calculating from the month that she said she has not been paid. It will go to 51 months, my Lord. And if you are calculating 5,000 rupees, which we said we will pay, then that would run to 2,55,000 only, which means, my Lord, we have even paid excess to her, my Lord, 4,80,000. 4,80,000, my Lord. So therefore, my Lord, this is what So
now you're asking for refund.
No, we will not.
Your
We will
Lordship.
not ask her to refund, my Lord. So what we want to bring to my Lord's notice is, because I have taken time to compute what is the payable amount. If we calculate by 5,000 rupees, we have already excess payment. We given payment to her, my Lord. So subject to what my Lord would say, therefore I'm saying that, because here again, my Lord, we are taking at the interest of her. Fully taking at the interest. There's nothing called adverse litigation against her, or we're not. The simple thing is that, my Lord, had there is a sanction post of four teachers, and now in that sanction post, my Lord, she stood as a fourth. So merit 1, 2, 3, the merit list we had to give. So they are enjoying the salary. Now for the fourth teacher, we are an SSA teacher. We cannot generate any other fund, and we have no source of generating any other fund also, my Lord. Had we have the fund, we have no problem in keeping her also, my Lord. But that is only difficulty that we also have. The school is facing. It's a small school, my Lord, with now the school.
What's the enrollment?
Enrollment 55, my Lord, now. 3 teachers.
How many classes are there?
It's a lower primary, my Lord. Up to class 4, my Lord. Class 4.
Yes.
Your Lordship, my calculation is different, because when I filed the petition, at that point of time, there's no dispute of the salary of 15,000. And after I filed the petition, the court was directed the MC to pay the salary, and I received the remaining salary, the due salary, from the month of May 2020 to December 2022 in 2 installment, Your Lordship.
December 22.
Yes, Your Lordship. So
How much you receive altogether?
amounted to 4,80,000.
Like they said, yes.
Yes, Your Lordship. And then after the adjusted amount of 5,000, so I pray that the adjusted amount may be applied starting from December or January 2023, Your Lordship. I think so that will be fair enough. Because there's no dispute with the salary. Only after Your Honor have adjusted the amount. So now the MC come with that conclusion.
We will take instruction on
Give
that.
her 1 lakh.
Yes, Your Lordship, in that case, because even I calculated till the month of June and it comes to 90,000, so 1 lakh will...
1 1 lakh and end the service.
We'll end this in the matter, yes.
1 lakh, my lord, I'll just take instruction. On the next day, I'll come back, my lord.
Submit instructions that he. Please, he would want some time, more time to instructions. Yes. Pay 1 lakh, we'll close the matter.
My lord. Obliged.
Obliged, Your Lordship.
22.
Yes, Mr. Nomri.
Please, Your Lordship. Lordship, this is the matter which was service as typist grade 3. Thereafter, Your Lordship, I participated in the speed test.
Oh, that one?
Yes, Your Lordship.
You opted what to do?
Your Lordship, I'll just have
You got the authority?
2 points, Your Lordship.
No, what authority do you have?
Authority is, my case is basically on the line that the speed test notice, which was called, which I will take Your Lordship to, page 28.
Yes. Page 28.
28, Your Lordship. Annexure 3.
Yes.
As per this notice, Your Lordship, this notice, I'll just read, Your Lordship. Enclosed, please find herewith a copy of the notification bearing so-so, number so-so, dated 5/12/2012 from Secretary Personnel so-and-so, which is self-explanatory for your necessary action. This was specifically based on the government notification, Your Lordship, 5/12/2012. You are requested to inform the undersigned whether you intend to appear for the speed test for typist grade 2 on or before 19/8/2016, so that the matter may be referred to MPSC for necessary action. Your Lordship, this government notification dated 5/12/2012 is on the next page, Your Lordship, page 29, which, as per this notice, they refer to this notification, Your Lordship. This is amendment of Rule 11, Your Lordship.
Yes.
Amendment Rule 11, it will be Rule 11(2). I'll just read, Your Lordship. Typist grade 3, typist with a minimum of 3 years of qualifying service in grade 3 shall be eligible for appearing in the speed test of 45 words per minute to be conducted by the Meghalaya MPSC, and their placement in the grade shall be subject to passing the speed test. This is the line, Your Lordship, which I want to stress, that placement in the grade shall be subject to passing the speed test.
Yes. So you didn't pass speed test?
No, Your Lordship.
You can't. But where's the other one that Mr. Shah has shown? The ones you opt for this.
That is Office Memorandum, Your Lordship.
Yes.
That is at page 46. Relevant will be Rule 5A, Your Lordship.
Yes.
Just read, Your Lordship. A typist who opt for the grade system shall continue as such, and he or she shall not be eligible for promotion to the post of LD, irrespective of his or her seniority in the cadre. But if Your Lordship would also come to Rule 2B in the same memorandum, Your Lordship, it's read, typists with minimum of 3 years qualifying service in grade 3 shall be eligible for appearing the speed test of 45 words per minute.
This 2B and 5A are
contradict, Your Lordship.
Yes.
And in fact, this is in consonance with the service rule, Your Lordship, Rule 2B.
Yes. What is the answer to that? Answer to that, you raise that conflict?
Yes, Your Lordship.
In the OM?
Yes, Your Lordship.
Who is the authority to interpret the OM in the case of any conflict in the rules?
Even if Your Lordship, 5A, which they have challenged, 5B also, Your Lordship, the appointment of...
No, but 5C, see, last time also, I think Mr. Lai has shown that option, once option, you accept option is final.
Lordship, yes.
Lordship,
if I remember correctly.
option. If Your Lordship...
Option, once you accept option is final.
Yes, Your Lordship.
Irrespective, that means irrespective whether you pass official speed test, that means...
with regard to that option, Your Lordship...
The thing is that now interpretation of the 2B, you see, typists of minimum 3 years qualified shall be eligible for appearing the speed test for hours per minute to conduct for and person with grades are subject to it. Now it's only that if you would, whether only if you pass
the
grade.
speed test.
If you feel also, that doesn't mean that you you go back, you revert back to the other cadre.
It doesn't.
You'll be stuck. Once you opted, you've opted.
It's silent, Your Lordship, on that issue.
It's not silent. It's if you pass,
if you pass, I'll be the grade.
But if you fail, you're still in that.
In the same post.
In a typist post.
Typist post, Your Lordship. Here on this issue, Your Lordship.
Because you see, if what I understand correctly is that they're trying to create a feeder grade for LDAs, correct?
Yes,
so if you opt for the grade system, that means you would remove yourself from the feeder grade. Is that correct, Mr. Shulai?
Lordship, yes. Correct.
That is what is the purport of this office memorandum?
This Lordship, I'll just submit, Your Lordship. Right from.
Let him say yes. Let him submit.
Right from the date of inception, from the very beginning, Your Lordship, as per Rule 10 and 11, Your Lordship, the post of typist has already been categorized into grade system, Your Lordship. That is senior grade and ordinary grade. Ordinary grade comes to grade 1, grade 2, grade 3. Right from the very beginning, Your Lordship, as per Rule 10, Your Lordship.
No, see, Mr. Lombry is in consonance only. Creation of this typist grade as per notification 512 is shows how you're going to be placed on what grade subject to passing the test. Now your case that you failed it. You failed it, now you exercise the option to take a speed test based on the grade. You failed it, now you've removed yourself from the feeder cadre for LDA. They said once you opted there, then we can't consider you for promotion to LDA. That's all.
One thing also, Your Lordship, I'd like to point out, like as per that notice which was called for speed test, Your Lordship, there's no reference made to this office memorandum, Your Lordship. It's clearly based on the government notification, Rule 11.2, Your Lordship.
That should be known to you. You're already an educated person serving there.
I'm just a grade 3 employee, Your Lordship.
What does Mr. Shulai say? Yes, we'll reserve it for judgment only 1 or 2 minutes. Yes. We'll pass orders, yes. What do you say in the affidavit? Same thing.
The affidavit is very clear, Your Lordship, but kindly come.
Where's the authority? I think we stopped the hearing because we said I asked you to come with authorities.
Lordship, authority, I was.
You want see, a court can give you a hint like office memorandum cannot override rules 309. Now where's that authority?
This authority I have, Your Lordship.
You have?
Yes, Your Lordship.
Yes. There's the authorities. Yes. I don't know, Joe. What is this?
Lordship, this is Lordship, kindly come to para 58.
Ashok Kumar Agarwal?
Lordship, yes.
Para?
Para 58, Your Lordship.
But this is with regard to suspension.
No, Lordship, no suspension. This is regarding that the government has the power, Your Lordship, to supplant the rules and issue instruction accordingly.
Aware of this.
Lordship will find at para 58 at internal page 172 of that Union of India versus Ashok Kumar Agarwal.
Okay, that's it.
And then another one, Your Lordship. Lordship, that.
Please, Lordship, this. Highlight 2023.
Because Our Lordship, that option is final. Your Lordship, kindly come to page.
1 second.
46.
Let's listen. Which paragraph of this Ashok Ram Parhad?
This is at paragraph 29 and 31, Your Lordship. May I read, Your Lordship? We fail to appreciate how the judgment of Prafulla Kumar's Swain case can be distinguished in this behalf merely in reason of regulation therein containing the expression only. It is not necessary to refer to factual scenarios of different judgment and different rules of general definition of what would amount to be on duty. When the rule in question is quite clear, we say so even in the context of the judgment in R.S. Ajara case, as in any service, whether on the issue of appointment or promotion. It is what the rule says, which will matter. One cannot derive general principle to decide such issues. We do appreciate that there can be scenarios where the rule specifically states to the contra, but in the present case, the very factum of proviso to Rule 2 of the 1984 rules being inserted in the rule has to be assigned a meaning, as otherwise it would imply that the proviso has become odious. It cannot be said that the proviso is not to be read in the context of the aspect of promotion. And 31, Your
Okay.
Lordship.
The next one, that is 2023, SEC Online. SC 265. And the next one is?
Next one is AIR to 1990, Your Lordship.
2001? Okay,
2000.
1990, okay. 1990 is, okay.
Paragraph 10 and 11, Your Lordship.
You see, Officer can't amend the rules. You see it's amendments or clarification? Yes, good judgment on this is yes. This is load. Para?
Para 10 and 11, Your Lordship.
It is 1990 judgment.
Yes, Your Lordship.
Okay. Yes, that's clear. Executive instruction can't override statutory rules.
Your Lordship.
Yes. And it's at 2001?
2001, Your Lordship, this is settled position of law that no government order or notification or circular can be substitute of the statutory rules framed with the authority of law. This is relevant paragraph is 6, 7 and 8, Your Lordship.
6, 7, and 8. You challenge him for the memorandum here?
Yes,
You
Your
did
Lordship.
petition?
Yes, yes.
Okay, that's it?
Yes, Your Lordship.
Yes, very conclude judgment is service.
25.
Your Lordship, just small request.
One more?
No, Your Lordship, I just
update.
Just update, Your Lordship. Just. Highly obliged.
Offline law.
Yes.
May I please, Lordship? The transfer matter, my lord.
Where's 1125? Mr. Mumin. You there, the matter?
No, Your Lordship. Your Lordship, Mr. Senkan is
Yes,
library
Mr.
for some accommodation on his behalf, Your Lordship.
Yes, my lord.
So urgency is there?
My lord, yes, my lord, the transfer matter only small issue with regard to the impugn order, whether it is a reason order or not, only with regard to that only, my lord.
Okay, after 1 week.
My lord, yes, my lord.
Mr. Sheikh?
I was transferred, then transfer was stayed.
Yes, my lord.
I was transferred, later on the transfer order was stayed.
I joined the service.
Oh, you're the influential person
Yes,
who's repeatedly got the transfer order stayed.
Yes, my lord.
Yes.
My lord.
Okay.
Highly obliged.
Obliged, Your Lordship.